morning and day. All persons have anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning, everyone. Welcome to the Appeals Court. I am Justice Rubin, and I am lucky, and you are lucky, that I have such excellent colleagues with me. They are Justice Massing to my right, Justice Grant to my left. We will be hearing, the case is a little out of order this morning, because I gather we've had some issues with some people making it in a timely fashion. So the rules are as they always are here, which is to say 15 minutes per side. There is no rebuttal. And we're going to begin, fingers crossed, with number 23-561. This is JB versus MD. And I gather we will hear from Attorney Farrell.
Yes, thank you very much. Good morning. May it please the court. This court should vacate the harassment order issued in 2023 for 3 reasons. The first, the plaintiff submitted no evidence and failed to prove by a preponderance of the evidence that the defendant had the subjective intent to willfully or maliciously intend to cause fear, abuse, or damage to property. Second, the court exceeded its authority under Mass General Laws, Chapter 258E, when it, in effect, evicted the defendant and removed him from his home when more narrowly tailored options were available that would not have left the defendant homeless after issuing the 258E. And finally, the court improperly ignored the landlord-tenant relationship by ruling that the hearing was, quote, not a hearing on any housing court matters, and that the court was, quote, not the forum for issues arising from the tenancy created between the parties. Therefore, the district court expressly failed to, quote, carefully evaluate the evidence to ensure that 258E is not used as a shortcut for evicting tenants without following summary process procedures. In terms of the first argument, there was no subjective intent presented, no evidence of the subjective intent presented by the plaintiff, nor was there any...
No, there's never any evidence of subjective intent. It's always an inference, right?
Well, yes, absolutely.
Like I didn't, I maliciously intended to get in her face. I mean, that's right.
Absolutely. But there's usually corroborative evidence, which in this case there wasn't any. Yes, in order to show the subjective intent of the defendant, absolutely. I believe there would have to be some sort of corroborative evidence. And
so for a plaintiff to get a restraining order, they can't just come in and say, I'm afraid of this person and they did X, Y, and Z.
No, Your Honor. There would need to be some evidence of the subjective intent.
Their testimony is evidence.
Absolutely. However, again, the plaintiff did not testify as to any evidence of that subjective intent. What was the intent of doing these things? And in fact,
well, I mean, he became, she said he was angry, he yelled, he got in her face. Can't you infer an intent from that?
An intent to be angry, absolutely. And if you look at the circumstances surrounding that conversation, the intent was not to harass or to cause fear or intimidation. It was to have an argument about a unilateral increase in rent that the landlord was trying to foist upon him. That's what this was about, and that's where CER versus PC comes in, where if the court had analyzed that situation and shown that, and seen the evidence in light that perhaps this landlord was attempting to evict this tenant without going through the summary process procedure.
Well, speaking of CER versus PC, what do we do with footnote 17? Can we order expungement in the first instance?
Well, Your Honor, in terms of expungement, that comes through after the order is vacated under Section 9 of 258.
But I thought the parties filed a stipulation to vacate.
Yes, it is. We did file a stipulation to vacate, which we can address absolutely. However, I'm
you
also
filed it in this court, right?
Yes, we filed it in the trial court, which was denied, and then the parties just tried to file it here, and I understand that we're asking the court to order the lower court to vacate the harassment.
Was it not accepted for filing? What do you mean you tried to file it here?
No, we filed it here,
Okay.
trying to get this court to order the.
So let me ask you this. You say vacate ab initio. Do you think we have the power to do that based on a stipulation?
Your Honor, I think you have the power to vacate as a modification. The trial court certainly does. To vacate the order.
But you haven't given a reason. So, for example, if you'd said, and here's an affidavit from the opposing party that says, I was lying, or something, then we'd maybe be able to say like, oh, I see.
Yes, and we certainly weren't able to get that, obviously. However, under Section 3, the parties can modify the harassment order at any time.
Okay, so in terms of, well, but it's terminated.
need.
It's terminated already, right?
That's correct, but the records still remain.
All right, so here's, let's talk very briefly about the records. I don't know if you're aware of this because this statute is written so badly, and then it's been construed in ways that are contrary to its language, and so people get very confused about it. There are two kinds of records of this. One are the records that have been shared with local law enforcement. Section 9 talks about when it's vacated, maybe even when it's terminated, those have to be destroyed.
That's correct.
There is also a registry of, I don't know what the phrase is exactly, but a domestic violence registry. So far as I am aware, except for fraud on the court, all courts somehow lack power to expunge this record. So you're not asking us to expunge that record, are you?
I don't believe there is the authority to do that. I agree with you, Your Honor. This is...
So you're just saying vacate, and what naturally follows from vacate, as I read Section 9, is the police, and I don't remember, there's some other agency, have to destroy.
Absolutely.
And that's all you're asking for?
That's correct. Yes. So in terms of the subjective intent, there was no evidence
I think that argument that there's no evidence of intent is not a very good one. I'd like to redirect you to, what would you say, I mean, in terms of I believe that your position is that our case law, even though that it says, you can have an intent to intimidate, that has been interpreted to mean it's got to be a true threat, right?
Yes, in terms of words spoken. To get around the First Amendment, right? In this case, the judge does not cite any of the words that the defendant allegedly said, and in fact, the evidence is very sketchy on what actually was said during these arguments. What the judge cited was the actions of getting in the face. And that is what I'm saying in terms of true threat or anything like that. That's why I don't cite any of those cases, because the First Amendment isn't implicated. It's his actions that the judge cites after the initial motion to vacate was heard in her ruling. And so the getting in her face were two instances of that. Those were the first two instances of harassment that the court cites. And if you look at it in the context of the landlord-tenant relationship, which the court refused to do, and under CER versus PC, my third argument, the court has an obligation to do that so that the summary process procedure is not sidestepped by landlords. And if you look at that relationship, this was an argument about a unilateral increase in rent, almost a 40% increase in rent after a month of living there. Second is...
Hold on. Can we stick with the actions of getting in her face? I'm not quite...
Sure.
So,
this...
do you concede there were two that were found by the judge?
Yes, there were two found by the judge. The
does the
details are sketchy.
Does the evidence support that? Or is that clearly erroneous?
In terms of clearly erroneous, that's a high bar to clear. And it was testified to. If you piecemeal some affidavits and testimony together, if you read the transcript and the affidavits, I don't believe it's clear error
Okay.
for the judge
So
to
then
have
what
found
you are
two
saying is that
instances.
the action of getting in her face was not intended to be to threaten bodily harm or injury or anything personal. It was in the context of, I mean, is it to say I'm not going to, if you raise my rent, I'm going to hurt you?
No, nothing of that was testified to, nothing was cited by the judge. It was just, you got in my face during an argument about, and it was really two things. It was the rent increase and a notice of eviction that the landlord had sent after breaking into his kitchen, essentially, and taking pictures. It upset him greatly, obviously, as that would upset anyone. And that is the argument, and that was the intent.
So there are these two get-in-your-faces, and you have to put someone, it has to be directed at one person, you have to thrice put someone in fear of imminent bodily harm. And getting in someone's face might be, obviously depends on context, and it might be that.
Context is key.
But let's look at the other two.
Yes, Your Honor.
I'm not crazy about he paid his rent and therefore well, actually, I don't know.
Yes, Your Honor.
When did that occur? After the order issued?
Well, it occurred after the ex parte hearing. He was, so the defendant was actually in Pennsylvania when all of this happened. He got a call on January 9th that an order had issued. He was not aware of any of the terms of it. It was just a quick call from the police. And then he paid rent over Venmo because
Can the
rent was due
third
January 9th.
act be before the two-party hearing?
I would think not, Your Honor, but
Because
even
then there's
so,
no initial ex parte order at the time that this is filed.
and Your Honor, I don't believe he had notice of the terms of.
And even violating it, that's not what the statute talks about. It talks about putting her in fear of physical harm.
That's correct. And
We
paying
don't
rent
have-
over Venmo.
He could have put an emoji with the Venmo payment that might have been very scary.
But that's not in evidence. That's not what we have here. And absolutely, and you can write notes
So then
on the
let's
Venmo,
talk
absolutely.
about the camera. I understand
Yes.
your factual argument about it, but the judge says,
Yes.
place a camera in someone else's kitchen.
Your Honor, I cite to two cases here, FWT versus FT and CER versus PC. CER versus PC is our North Star here. But in those two cases involve cameras and violations of privacy. In FWT versus FT, it was the defendant flew a drone over his son's property, private property, and interfered with workers and was a nuisance. And that was found because there was a lack of evidence that the intent was to cause fear or intimidation, that was not an instance of harassment.
Fear of physical harm.
That's correct. Now, in CER versus PC,
I can understand how a camera would make someone afraid, and it might intimidate them if that were really what the statute meant.
Right.
But of course, the statute, despite having the word intimidate in it, has been narrowed to true threats, basically.
Sure, and willful and malicious conduct. And with CER versus PC, it was a very, very similar case to this one, where it's the defendant tenants were trying to be evicted by the landlord, and they set up a camera facing the driveway and also into the living room where the plaintiff landlord lived. And because of the circumstances, because the landlord, the true purpose behind all of this was to evict those tenants, there simply wasn't enough evidence that those cameras were placed there maliciously or willfully with intent to cause fear or intimidation. And in this case, if you look at the timeline in October, he moves in September, October, she tries to unilaterally increase the rent against the lease by 40%, $400. That's in October. In November, he receives a notice of eviction after he refuses to pay the extra $400 because it's a violation of the lease. He receives this notice of eviction that references photographs, and he sees photographs of his own kitchen that has a separate lock. That's his own private living area that she has broken into and taken pictures of and used to try to evict him. And then, that is when he purchases the cameras. And that's clear on the record. And that's when it is found in his own kitchen, and then the plaintiff landlord allegedly finds it in her kitchen. And so the intent here was not to intimidate, it was to protect his own property. The layout of the house, he had a basement apartment, he had to walk through the kitchen.
We're running short on time, and these all sound like factual arguments.
Yes, Your Honor.
That we're not a fact-finding court.
Yes, Your Honor.
What I still don't understand is, you filed this stipulation that the order is void ab initio, but you filed it in this court. Have you filed it in the trial court?
Yes.
And have you asked them to expunge or
He
vacate?
attached that to his response to it.
Okay.
And that was denied, and I did in my supplemental memorandum, I believe the court incorrectly denied that motion based on a faulty reading of the case law.
Is there a written opinion with that?
I'm sorry?
Is there a written opinion
Yes.
with that denial?
I attached it to my memorandum. It is a marginal written opinion.
I see.
On the first page. And my time is up.
Your time is up, although if there were further questions. Thank you very much. Excellent
Thank you.
argument. It appears that we could return to our ordinary order. So we're going to, rather than going on to case 4 right now, we're actually going to go back to case 1. This is number 24-42, Lee versus Lee. And we will hear first from Attorney Sawin.
Good morning, Your Honor, and may it please the Court. My name is Attorney Sawin. I represent the appellant, Matthew Lee. I'm here seeking to vacate a judgment of dismissal of a divorce action out of the Plymouth Probate and Family Court. The court, in that matter, the lower court, dismissed the divorce on the basis of 3 actions. 1, on the lack of subject matter jurisdiction. 2, on the lack of personal jurisdiction of the wife who resides in Tennessee. And 3, on the rare doctrine of forum nonconvenience. With respect to the lack of subject matter jurisdiction for a process of pending divorce, it's the responsibility of the plaintiff to demonstrate that he's either been a resident of Massachusetts for 1 year or that he had been domiciled in the Commonwealth when the action was commenced. The action.
So the Judge Conley made some pretty detailed findings of fact that your client was not domiciled or resident in Massachusetts continuously for a year, based on the fact that his cars were registered in Tennessee, he wasn't registered to vote in Massachusetts, he didn't have a Massachusetts driver's license. How can we get past all those detailed findings of fact?
Yes, Your Honor. So although those are factors for residency, my client can also satisfy the requirement of being domiciled in Massachusetts, which is slightly different than residency. So although when he
But that's a fact finding, right? Domicile is a question of fact.
Yes, Your Honor.
And we have a judge who we'd have to find it was clearly erroneous to say that your client wasn't domiciled here on the day that this was filed. And I think the difference is between residency and domicile, although this seems like an oversimplification, is intent permanently to remain.
I would agree with you, Your Honor.
So the judge must have found either a shortness of residency at all, or an absence of an intent permanently to remain. How can we say that's clear error?
Well, Your Honor, I'll say that's a clear error because there's a number of different factors that would demonstrate that my client, in fact, had the intent to permanently reside in Massachusetts. He accepted a job here in Massachusetts. He told his wife, he told his children that he was moving to Massachusetts and not returning home.
But there's plenty of stuff pointing the other way. I mean, I agree. Obviously, some of the stuff points one way, some of the stuff points the other way. But there's also he had worked out of state before. There's also he went home for Thanksgiving and Christmas and did the chores. Right? You know what I mean? It's not crystally clear by any means. And the judge looked at all of it and heard the witnesses and said, I don't think he had the intent permanently to remain. How can we overturn that? How could that be clear error?
Well, Your Honor, there was only one witness that testified at this evidentiary hearing, and that was my client. The wife refused to appear, she refused to testify, and so I would suggest to the court that because of the testimony of my client, there's no counter testimony that would demonstrate otherwise. So I understand it's a little unusual that my client...
Well, but intent is something that, as Justice Massing mentioned in the last case, intent is something that we ordinarily determine not just by the words said by the person, but by circumstantial evidence as well. And an intent permanently to remain, many of the things that one might look for, like that his car was here, or that he had changed his driver's license or voter registration. These things hadn't happened, which isn't to say, I mean, I'm not saying I didn't hear the witness, I don't have any way to judge credibility and so on, but I just don't see how it has to be clear error. And there are things that point to not intent permanently to remain, intent eventually to go back to Tennessee, including mortgaging the house. I mean, I suppose that was a year before.
Yes, Your Honor. So that was a year before the refi of the mortgage. But again, simply because he went home several times throughout the year to visit his children doesn't mean he didn't have the intent to permanently reside in Massachusetts.
But could the wife have filed for divorce in Georgia?
Tennessee, Your Honor, yes.
No, in Georgia.
No, Your Honor. None of the parties reside in Georgia.
She worked in Georgia every day.
Correct, but they don't. I'm not familiar with Georgia law, but my understanding is that they didn't meet the residency requirements to file in Georgia. But don't quote me on that, I suppose. With respect to him going home and doing some chores around the house, I mean, it's a little unusual, but those types of things happen all the time with divorce.
It's a question of whether it's some evidence. You know what I mean? Just by saying it's unusual, it's like, okay, it's unusual, and yet he did it, and so maybe that supports the judge's finding of non-domiciliary. Doesn't prove it, but nothing proves it here either way. The judge has to find it as a fact, at least as I understand it, that it's not a legal question.
Yes, Your Honor. Part of the issue is that, you know, he moved a considerable amount of his items from Tennessee to Massachusetts. His vehicle, he testified that the reason why he didn't change his driver's license or registration over right away was a matter of convenience. I understand those are just mere factors from the case law, but he did do those things prior to the evidentiary hearing. I'm not aware of any...
Yeah, but after filing the divorce papers, the question is on the day he filed the divorce, isn't it, for domicile?
It is, Your Honor.
Can you talk about forum nonconvenience because you have a limited amount of time?
Sure, Your Honor. So I know that forum nonconvenience is somewhat of an uncommon, I would venture to even say almost a rare doctrine to use, especially in divorce law. I understand it was my sister's obligation to demonstrate that there was an alternative forum that the action could be filed, which I agree it absolutely could have been filed in Tennessee, but it wasn't until after the fact. But also the second prong is that there have to be the balance of private and public concerns that strongly favor the alternative forum. Although the marital home is in Tennessee, there's plenty of divorces that happen in Massachusetts where there's real property in sister states. I don't think that alone is strong enough to make a determination that forum nonconvenience makes this divorce dismissed out of Massachusetts. Moreover, there was no evidence from the wife to demonstrate what witnesses, if any, would be testifying at this divorce. And I know that...
Well, she'd have to come up here.
Sure. Absolutely, Your Honor, but that happens with other divorces all the time. I have other divorces that are pending where there's someone that lives out of state and they have to travel to Massachusetts to testify.
She hasn't been here since 2017.
Yes, Your Honor. But that doesn't mean she wouldn't, that doesn't mean she hasn't purposely availed herself in the past.
But it's a question of forum nonconvenience.
Correct.
And so it's not just that they own real property here. This isn't their summer house. This is where they've lived the whole time until a year before the divorce papers are filed at most. So I'm not sure, you know, obviously I'm not sure that it meets the test for forum nonconvenience, but it's not, to say the center of gravity of this marriage was in Tennessee seems obvious.
I don't disagree that the center of it is in Tennessee. However, I would suggest to the court that simply because the marital home was in Tennessee is not enough for the second prong. Because I don't think there was enough evidence demonstrated by the wife that it would be more convenient for the matter to be litigated in Tennessee as opposed to Massachusetts.
But wouldn't a probate judge would have to make decisions about things like whether or not the parties should continue paying private school tuition for the younger kid, and whether or not, you know, what the custody arrangements would be, and how far apart they live. And a probate judge in Massachusetts, how are they going to do that about Tennessee?
Well, Your Honor, I would suggest that matter is moot because the youngest child is now 18. But at the time, when I filed this divorce, and I've done this with other divorces in the past, I purposely did not check off the custody box on the complaint, but the registry made me check it off in order for me to file the divorce, so that's what I did. But it was never the intent to litigate custody. My client wasn't contesting custody for that at all.
But there's issues about property in Tennessee that a Tennessee probate judge would be more familiar with than a Massachusetts probate judge.
Maybe, Your Honor, but that's why we have real estate appraisal specialists who would appraise the property, and then there would be some report that the judge can rely on. I mean, I would suggest that simply because a judge in Tennessee resides in Tennessee doesn't necessarily mean they're familiar with a property in a particular town or county. Maybe that's the case, but, you know, plenty of divorces happen in Massachusetts where judges aren't familiar with the area and they rely on experts.
They're familiar with the law.
Yes, Your Honor.
I mean, I don't know, I'm not thinking off the top of my head what might differ. I mean, there might be different ways of holding property in Tennessee. I have no idea. When people get divorced, I know what happens here or what some of the options are about jointly owned property. Maybe Tennessee has different rules about that. Obviously, our court would have to some degree, figure that out. You can't just order another state to, you know, to create a legal mechanism for holding property they don't have, right? It would have to be in compliance with that.
I agree with you, Your Honor, but that wasn't evidence that came in at the evidentiary hearing. There was no evidence from the wife to suggest that there was some sort of issue of legal title to the property that would somehow confuse a probate court judge in Massachusetts.
But what do we do then with the comment in Rose v. Rose, quoting a Supreme Court case saying that parties in courts have an interest in avoiding officious and intermeddling with the law and the procedures in other states? Does the wife have to show that we'd be officiously intermeddling if we said that this case could lie in Massachusetts, or is it the plaintiff's burden?
I would suggest it's the defendant's burden, Your Honor, because it is a somewhat unusual doctrine that's raised by the defendant. I believe the burden is on her by a preponderance of the evidence to demonstrate that it would be judicially impractical to litigate the matter in Massachusetts as opposed to Tennessee, and I just don't think enough sufficient evidence was brought in via the evidentiary hearing, mainly because the wife didn't testify. And I understand it was mainly an argument from counsel as to why it would be more convenient to litigate in Massachusetts versus Tennessee, but I would suggest that ease of litigation alone is not sufficient. There are two prongs to forum nonconvenience, and I don't dispute the first prong. Clearly, the wife could have filed in Tennessee, but she didn't. But the second prong, you know, again, it has to, quote, strongly favor the alternative forum, and I just don't think there was enough evidence brought in to demonstrate that. With respect to the issue of, and I'm happy to talk more about forum nonconvenience if any of your honors wish me to, otherwise I'm going to move on to personal jurisdiction. With respect to personal jurisdiction, clearly I would suggest to the court that the wife had certainly availed herself to Massachusetts on a number of occasions. She came here to attend a wedding. She was here for a number of different times, 9 different times throughout the course of nearly 20 years that she had been here. When she came here with her children, with the husband. They stayed with family. I know part of my sister's red brief suggests that the wife has no contacts in Massachusetts. That's just simply not true. All of the husbands has cousins and aunts and uncles in Massachusetts.
Those are the wife's contacts?
No, Your Honor, but when she came to Massachusetts with the husband, they stayed with those family members. She talks to them on a somewhat regular basis, is my understanding. And to suggest that simply because no blood relation exists between wife and those individuals, I would suggest doesn't make the contacts not strong enough.
Someone from Georgia loves Broadway theater. And so while they were married, not in several years, but they used to come up to New York City to see a show. They'd stay in a hotel and fly back. Is that the kind of contacts that would create minimum contacts for a divorce action?
I think under that limited fact pattern, I don't believe so, Your Honor, but I believe this fact pattern is a little different.
Because they stayed with relatives.
They stayed with relatives, they vacationed here, they rented vehicles here, they held themselves out as a family unit here, they attended a wedding here, they attended a
So when
funeral
people from
here.
out of state come to the Cape to vacation, is that the kind of contacts that is enough for later on for their divorce?
Your Honor, I think it's the totality of the circumstances. When you look at all the different slivers of how often they've been here and why they were here and the duration of time that they were each here, and you put them all together, I would suggest at that point it creates minimum contacts. But if you look at them individually, I would agree with Your Honor that it's simply not enough. But if you put them all together, that's how you get the whole pie. And I think that is enough to make minimum contacts. Especially when there were times that the wife came to Massachusetts by herself, I believe. And I would suggest that the case law that I cited on page 17 of my brief, especially in the Miller section, which has to do with the act that gave rise to the claim of divorce, it's a subjective intent. Strike that. It's a subjective feeling of my client as to when he thought the divorce was over. And they were having communications when my client was here in Massachusetts. They were texting, they were having phone calls. My client made the wife aware that he was not happy. And that, I would suggest, at some point led to the straw that broke the camel's back, which is the key phrase of one of the cases I've cited in my memo as well. And I understand that my time is running low. If there are any questions from the panel, I'm happy to answer those.
I see none. Thank you very much for an excellent argument.
Thank you, Your Honor.
We will hear now from Attorney Belinsky.
Thank you, and good morning, Your Honors. May it please the Court. My name is Eileen Belinsky, and I represent the appellee, Mary Beth Lee, in this matter. And our position is very straightforward and simple, and that is that Judge Connolly's decision was the correct decision. It was based appropriately on the facts that he heard, the evidence that was presented to him. He applied the law, and he wrote a very informed, detailed decision, and that decision ought to be upheld and affirmed by this Court. There is no subject matter jurisdiction. There is no personal jurisdiction over my client, and the Court found that Massachusetts was a forum that would not be convenient to try this case. And as the Court pointed out in questions, I know that you understand that from hearing that. I would only want to point out a fact or two that Mr. Samwin made that, in my opinion, is incorrect and is not substantiated by the record, and I would ask the Court to use your own recollection of the record and what you have seen. And that, in particular, was that Mary Beth Lee came to Massachusetts on her own. She never came to Massachusetts on her own. She was always, and that's not evidence, that's not any part of the record that I recall seeing, nor is it any part of a record that I ever recall hearing. I was the evidentiary hearing. I have been involved in this from the beginning. I never heard that fact, but I ask you just to use your own recollection. Ms. Lee came in.
You made a special appearance, right?
I did.
And part of the reason why you didn't call your client as a witness because she would have had to come to Massachusetts.
That is correct, Judge. She would not have been able to stand on her special appearance if she came into court, and that was said to in the brief, and it was also said to Judge Connolly on more than one occasion when he questioned it. She could not appear in person, nor could she appear by Zoom, because that would have immediately subjected her to personal jurisdiction, and in that case, any position we took on subject matter or personal jurisdiction would have then been eliminated. Ms. Lee came to Massachusetts the last time for a family wedding in October of 2017 and never has stepped foot in this Commonwealth again. The questions that the court had before on the issues of subject matter of where did Mr. Lee say he resided, and I would urge the court again to look at the record and see that notwithstanding what he said on his complaint for divorce, his actions on the issue of residency, on the issue of domicile, and as well on the issue of cause, all contradict his statements. His actions have contradicted his statements. His actions of doing nothing to show that Massachusetts was his new home is very clear. The court raised the issue that things that the court has held in the past on prior cases, Miller, Fiorentino, Rose, Caffin, all state things that are indicative of making this state your home, auto registration, bank accounts, leased property, the majority of your personal property.
Where was he living at the time the complaint was filed?
When he was living in Hanover, Your Honor, and that was at his aunt and uncle's house.
During the entire year he stayed at his aunt and uncle's house?
That's what he testified to. It wasn't until when he wasn't living in Tennessee. He was living in Massachusetts at his aunt and uncle's house in Hanover. It wasn't until October of 2022, which was just a few weeks before we had our evidentiary hearing and several weeks after the motion to dismiss was provided to him. He went out and leased an apartment in Clinton, Massachusetts, where he paid for all of the rents by a joint account with joint funds with his wife from Tennessee. That is established of him not having any presence here. The fact that he testified that he went home to Tennessee on several occasions, at least 6 in 2021, and I believe 6 in 2022 before Mrs. Lee was served with the complaint for divorce. And contrary to what counsel said, Mr. Lee never testified that he had conversations with his wife that he had moved permanently to Massachusetts. Mrs. Lee testified through an affidavit that she had no idea she was going to be served with divorce papers until she was, which was in July of 2022, months after he filed his complaint for divorce. The complaint for divorce is dated January of 2022. It was filed in March of 2022. He went home in April of 2022. He went home in July of 2022 and served her 9 days after he had been home for the last time. The only part of Mr. Lee's case that even potentially gave an issue to the judge was the issue about cause. When did the cause for divorce arise? Because under the statute for jurisdiction, it had to have arisen in Massachusetts, and the court has held that's always a subjective determination. But Mr. Lee himself never gave a specific date or specific information, testimony to the judge on the issue of when did the cause arise. His complaint for divorce says January 17th, 2021, and we last lived together in Hickson, Tennessee on that date. So he said in his paperwork the cause for divorce happened in Tennessee on the date they last lived together. It's in black and white. That's the complaint for divorce.
Didn't he come here on that day?
He left the house on that day and came to Massachusetts.
So part of the day he was here.
Presumably, yes, yes. But he said the cause happened then when we were living together, which meant Tennessee. The only part that even potentially wavered from that was when he was asked on cross-examination by his attorney, what was the conversation you and your wife had on a particular day that made you unhappy? And he wasn't able to articulate any specific information, such that the next question was, how did that conversation make you feel? To which Mr. Lee said, well, I wasn't as happy as I thought I would be. When asked what was the conversation about, he said general things when I had a conversation with my wife. We talked about the kids. We talked about my job interview. We talked about my opportunities. That's all he said. He never said, we had an argument about something or we had a disagreement. He didn't articulate anything that was similar to what was articulated in the Miller case, when husband and wife had conversations where husband made derogatory remarks about wife and had insulted her and caused her to believe that that's the date the marriage ended. His comment, page 120 of the transcript, said, I left that conversation unhappy. Not as happy as I thought I'd be. But we don't know, because there's nothing that suggests anything else, what made him unhappy. The fact that he didn't like a comment his wife made about job opportunities or employment or the kids? Or was he just unhappy because he wasn't at home in Tennessee sharing life with his wife again?
Well, I mean, there are straws that break camels' backs, right?
But the court has held that, as subjective as that is, there has to be something articulable. And I would point out that his behavior contradicted any straw that broke the camel back or anything that was said. Specifically, Judge, in 2021, there was text messages back and forth between he and his wife where he says, I've applied for jobs. He signed some love. He says in 2022, he sends her a Valentine's Day text that says something's going to be delivered tomorrow. I couldn't get it there today. Valentine's Day 2022.
Well, doesn't he fly back I don't know how he got there, go back to Tennessee for Thanksgiving and Christmas, and not only stay in the house, stay in the same bed with her?
Yes, Judge. This woman had no idea this was happening. He came home, he resumed the life that he was living, and this is a man that the evidence had been. He had worked away from home for weeks and months at the time because he was constantly either changing jobs, losing jobs, getting new ones. He worked 4 hours away in Humboldt, Tennessee for about 7 months, so he would come home for long weekends or holidays. He was always doing that, so coming home for Easter and coming home for July 4th, coming home for Christmas. Refinancing the mortgage that was started in October of 2020, concluded in December of 2020, and then he leaves a few weeks later. I don't even think it was a few weeks. I think it was more like a few days later in January of 2021. He said, I live here. But one of the most telling factors here, judges, is the fact that he filed the income tax returns for the family. There's a text message in the record that said, I filed our tax returns. You have to sign the Georgia one, but I filed the other ones. And the
Is residence a legal question?
I'm sorry?
Is residence a legal question?
I think it's more of a fact. It's legal and factual. It's a legal question insofar as that's the basis for subject matter and personal jurisdiction and falling within the statute, but it's also a factual one. What do you have to show you are a resident here? And he had nothing.
No, obviously, it's a question of whether the facts amount to residency.
Right.
But the finding of residency or the conclusion of residency or non-residency, I take it as a legal question.
I would say yes, in order to get to the standard of whether or not the court has jurisdiction over the parties and over the matter. And the judge made specific findings about that. And he made a finding in part that Mr. Lee's testimony was not credible. And that is something that this court has always held to be within the province of the trial court, of the hearing court. We did this, unlike, I think it's the Miller case that was done on affidavits. This one was initially scheduled to be about a 2-hour evidentiary hearing because it was only going to be one witness, but turned out to be well over 6 hours. There was a lot of testimony, and it was only one witness. It was Mr. Lee. He was the only one. There was a lot of evidence, a lot of testimony, and the judge was able to discern that in part he was not credible, he didn't meet the standards, some of his actions were well done, well after the filing. He just doesn't have it. This decision should be upheld. It should be affirmed by the court. Thank you very much.
Thank you very much. Excellent argument as well. The case is submitted.
Thank you.
The next matter is number 24252. This is Department of Children and Families versus Father. And it's an impounded case, as I'm sure counsel are all aware, so we don't use the names of parties or other family members. You can probably just limit yourself to descriptions like mother, father, child. And I believe that we will hear first from Attorney Bench.
Good morning, Your Honors. I'm Nathan Bench. I represent Appellant Father. I want to start by addressing Father's problematic history of domestic violence and undertreated mental health. Father is diagnosed with PTSD and borderline personality disorder. And since 2007 has had 6 209A orders taken against him, 5 by ex-romantic partners, and 1 by his sister. Now, despite Father's challenges with very serious disorders, he has demonstrated fitness for caring for the child. He has a virtually perfect visitation record, which is uncommon to say the least in these types of cases. Father is consistent, engaged in visits, loving, shows appropriate affection, which the child reciprocates. During the visits, he is really an exemplary father. And as the lower court cites, all reports from social workers, from those who have seen or overseen his visits for parental evaluations. And
if I thought the judge ordered 6 visits a year, right, which is that's a pretty generous order.
Certainly, it would be a generous order if Father were unfit.
I'm just saying, the judge agrees with you, there is a strong bond.
Right, definitely, yeah. There's evidence of a strong bond, thank you. And if that's all we were seeking, then we would be happy with that. But Father has demonstrated his fitness. And besides his treatment of the child during visitation, I think a key here is that almost a year, 10 months before trial, DCF placed brother in Father's care.
Where does it say in the record that DCF placed brother? Because I saw Dad's testimony that he had custody, he said, and care, he said, but I couldn't find any 51As and custody decision. There's talk about a Worcester probate court
Right.
custody agreement that Father came to with boy's mother, but we don't have that in the record as far as I can tell.
That's true. Let me just pull the finding. I don't want to take too much time on that because what is apparent, and I think this was in the testimony of the social workers as well, excuse me, is that there's an open case for brother. Brother is a consumer in the DCF system.
Because of whatever went on at the mother's house?
Correct.
so that the older child was removed from the mother's house by DCF.
Correct.
And maybe like one would do with, if another parent had no relationship with DCF, they eventually release the child to the other parent. But of course, in this case, the father is known to DCF, and yet they do this.
Exactly.
But how do we know they did it? Where does it say they did it, as opposed to the probate court doing it or the other mother doing it? And there's this talk about the paternal grandparents being involved. Do we know who has custody of the boy?
So I think finding 24 is, the court summarizes from various sources, that brother came to live with father in Holyoke, apparently because the Worcester Division of the department was involved with brother, his mother and stepfather. I don't want to get too into the weeds, because I think besides the fact that DCF is aware that brother is there and aware of father's history, father's care of brother demonstrates fitness.
Okay, so you say you don't want to get too deeply into the weeds. This actually seems like a critically important piece of this case, at least to me.
Okay.
That is, DCF knows everything it knows about the father.
Yes.
And I'm not advocating that they take the older child away from the father at all, but they haven't done so. They could walk right in there, presumably, and say, well, he's unfit. We've been saying it based on all these 51As or Bs, whatever we have now in this case, and they're not doing that. Now, you say part of the reason, I guess, is, or maybe it doesn't even matter about them, they do have to prove here by clear and convincing evidence that he's unfit, and yet their behavior suggests at least some question about that.
Right.
And then you say, and he's doing a great job with the child. And the judge says some stuff about that they argue or whatever, but we don't have any real detail. And I take it the reason we don't have any real detail is that the father has, and I certainly can't say this is crazy, but it's difficult, father's not letting DCF into the house, right, with the son. As I read, there's something I read in the record that says that.
Right.
Now, these are complex situations. I can understand why someone who's had his other child removed by these people might want to be as far away from them as possible. And the judge didn't draw negative inference from that. But we don't really know from the failure to cooperate, we don't really know how that's going, do we?
Right. And I apologize, I misspoke. I certainly do want to focus on this.
Yeah.
and on your questions, thank you. One thing I will say here, and what you mentioned, is DCF is deeply involved with father, with the other child, and with brother as a consumer. Even if they can't get into father's home, they certainly have access to brother. They have access to him at school.
But there was something in the testimony of, I think it was maybe redirect of father, about the fact that there was a social worker named Sam who learned for the first time at the June 2022 foster review hearing or meeting that dad had custody of older boy. So how do we know? I mean, there must be documentation out there from the Worcester Probate Court, maybe from 51As and 51Bs that have been filed involving older boy back to when he was 2009, when he was an infant.
Right.
That we don't have. And you're asking us to connect the dots to mean that somebody found dad to fit to parent older boy. And I don't think we can do that.
I understand. I see what you're saying about connecting the dots. I do know that in the record, within the 51As and Bs, there are mentions of brother. To me, it would be especially surprising for DCF to make this placement and for there to be no communication within that transfer. Whether the time...
But he was cross-examined about the fact that he didn't tell DCF for 6 months that he had older boy.
Right.
And you're saying we should draw a negative inference from the fact that DCF didn't do something about it?
Well, maybe not a negative inference, but I think what we can do is, as you mentioned, DCF became aware of it. And even if the amount of time, the time window is shorter than the 10 months, during that time, DCF took no action against father for his care. And to my knowledge, DCF retained legal custody of brother.
Factual finding 24 that you pointed us to, whatever DCF's opinion of his parenting, the judge didn't have a very good opinion of the parenting with the older child. The judge is, he enrolled him in the wrong school. He fights with them, and so I take it. You point out this irony that there are two children. One of them seems to have more special needs than the other, and yet he's not unfit to parent the one with the more needs, but he is unfit to parent one with the less needs. But isn't it, I at least infer from the judge's findings that, well, actually I don't infer, she says that she finds that removing him from, and this is consistent with 210.3C7 and adoption of Catherine, she says that removing him from that placement will create for her a host of social, emotional, and mental health needs, and that she doesn't think father would be able to handle.
Right. And I want to address, thank you, Judge. I want to address the first part where you're talking about where the judge characterizes father's treatment of brother as probative of unfitness for the child, when first, again, whether DCF had legal custody, really, I think this is an unfair and improper characterization. Honestly, if she mentions occasional shouting matches, and if occasional shouting matches with a defiant teenager was sufficient for a finding of unfitness, we'd be inundated with care and protection cases by almost every parent of a teenager. And then as far as the school decision, I honestly fail to see how that's relevant to a finding of fitness or abuse or neglect of a child. So whether DCF has legal custody or father does, father demonstrate fitness.
Do, so we can be in that school. We don't know.
Right. That may be missing from the record, as you said. There may not be that documentation there.
There's no sign that the grandparents have legal custody, though, of the
There was no
older
indication
child.
of that.
I have a hard time. I've known people of few means who actually mean to help their children by sending them to a nearby school district where they maybe don't actually reside, and I have a hard time, saying that shows unfitness, since they're trying to get their child a better education. But to go back to Judge Massing's question, there is this one piece of it, and I understand that this isn't the way the opinion is written. There is this one difference, which is removing the subject child here from her current placement may be profoundly destructive, whereas removing the older son from apparently a place that is no good to be may not have that profound effect, or at least the pros may well outweigh the cons. What do you say to that? I understand this isn't an opinion that says father would be fit, but for this terrible thing that will happen to the child.
Correct.
But if there's a terrible thing that will happen to the child, how can you change the custody?
Certainly, I think, as you mentioned at the beginning, these are tricky situations. The fact that the child would be harmed by removal does not make the child unique. When this happens, when a child's removed from birth especially, it's natural that there's also a bond with the caretakers, and father did testify that he would keep that relationship open. But as I said, that doesn't make this unique, and I do acknowledge that that it would be hard on daughter. However, father is fit to meet the child's needs. And
Well, not if the child is profoundly damaged in going there. I mean, we have specific cases, there are rules about them, but we have cases where the mere length of time, continuous time in the other setting has, well, I don't know, it's rendered the parent unfit, but on the basis of what would happen, they conclude unfitness having no moral judgment, just that you would destroy this child so you can't do it.
Correct.
I mean, that happens.
And I would like to mention briefly on that point that that conclusion is based on a bonding expert's testimony. And in this case, I think a really key point here is that the bonding expert never completed a parenting evaluation of father with brother, right? It was a 3-year-old evaluation. She hadn't seen father's great track record with the child. She hadn't seen father care for
Father
brother.
won't let DCF into the house where he is with the son. How is a bonding expert going to be able to come in and see what goes on there?
Well, there's also, I can see that point. Father did not allow DCF into the house. There's no evidence that DCF sought another bonding assessment after they were aware of brother's presence in the home. I see I am low on time. Are there any other questions from the panel?
Out, actually, but are there other questions? No? All right, thank you very much. A very unfortunate case and very well argued.
Thank you, Your Honor.
So thank you. We will next hear from Attorney Price.
Good morning. May it please the Court. Matthew Price on behalf of the Department of Children and Families. The Department is asking this Court to affirm the lower court's decision that terminated father's parental rights. The lower court decision was the correct one. Just to quickly respond to Justice Grant's point about how the older child came to live with father. My understanding from the transcript and the record is that a Springfield probate court gave custody to father. This was not a situation where the department came into the mother's house, removed the child, and found father as a placement.
Is DCF the legal custodian of the son?
I don't know. I don't know what the status was from the Springfield probate court. But what I do know...
Well, yes, but I mean, even I don't know when that may have been going on for years, that DCF is the legal custodian.
Correct.
Do you know what position DCF took in this Springfield proceeding?
No.
Or if they were party to it?
No, I don't know that. I don't know that that's in the record, other than that father had gone to the Springfield probate court to get the custody.
I think it's Worcester Probate Court, and I think that's part of the problem. There was discussion with the father in the transcript about the fact that somehow this ended up in the Worcester Probate Court, and the father at various points said there was information that the Worcester DCF office had that the Springfield DCF office had failed to obtain. So I don't know why that is. One of my questions for you is, do we have in the record the 51As and any 51Bs as a result of the, back from 2009 and I think 2013, involving the boy?
Involving?
Boy, older brother. It looks from the family assessments as though there was a 51A report filed in August of 2009. This is at RA2, page 197, alleging neglect by the father of boy. But we don't have that 51A. We just have a reference to it in the family assessment. And then there's another reference that when Dad was supervising Boy walked out of the house when he was little, and it looks as though that was unsupported, but we don't have the 51A. So Dad is asking us to connect the dots to say that somebody, whether it's DCF or Worcester probate or Springfield probate, determined that he was a fit parent to Boy. And I'm just wondering if you can shed any light on that.
I don't think I can shed a lot of light on the recent placement of how he got to, other than what I've already said about how he got into father's custody. What I would say to follow up, though, is that the court considered the situation that father was parenting the older child, and to point out that when this was taking place, it was approximately over a 10-month period of time, which I would suggest is a short sample size to...
But we have to have, or the judge has to have, and we have to find clear and convincing evidence of unfitness.
Correct.
And I guess my concern is this. Obviously, there is evidence of unfitness. The question is it clear and convincing? And if he is adequately raising his son, how can the evidence of his unfitness to raise his daughter be clear and convincing?
Well,
It may be strong even, but it has to be clear and convincing evidence. And
Well-
someone who's, there's no 51As so far, at least, in this situation where he's got his son back.
correct. In the 10-month period of time, there hadn't been 51As filed, but I would suggest that a parent can be an appropriate fit parent for one child, but not another.
Obviously, that's true, but that's not what the judge said, right? The order below isn't based on, well, he's fit to parent this child, but not this one, and here's why. Now we're beginning to do some guesswork about why that might be. But why might that be? Okay, so I agree with that. I don't know if it's fortunate or unfortunate. The judge says, well, the child will have special needs. And the judge says a number of things. The judge says, predicts that placement with the father would eventually lead to an immediate, this is a weird thing to say, right? Eventually lead to an immediate threat of harm. But if that's true, unless it's based on her gender, which the judge says that in one point, but I think that's a more general problem, this immediate threat of harm. That applies to the other child too, right? That's not a difference between them. Fit to do one but not the other. What are the
Well, I think, sorry, go ahead. I think the differences to be considered are, I think gender is one. Father has a long history of his aggressive behaviors and domestic violence towards women. The other thing is that...
So he can't raise a girl?
No, but I'm saying that that's one aspect that could be of concern, not the only aspect. The child is coming from, would be coming from the only home she's ever known. She hasn't lived with either of her parents. She is much younger than her older brother. And these are differences, I think, that...
I don't see how younger makes a difference.
Well,
It'd be easier to raise a younger child than a teenager.
I don't know if it's easier, but...
Different anyway.
Well, I would say that one of the concerns that the judge had was particularly the stages of development that child was going to go through and how that triggers or plays into father's mental health and the subsequent aggressive behavior, and how the mental health went untreated, particularly where there is a treatment, not a cure, the dialectical behavioral treatment that father was at least aware of in 2019.
Isn't there something, maybe it's in the findings, I don't know where it is, that it'll be years before that begins to pay off?
Yeah, there was
And yet
discussion about that.
he is with the son. I mean, I'm not saying it proves anything necessarily. It just, to me, undermines a lot of not all of, but a lot of the judge's conclusions, or at least undermines whether they're supported by clear and convincing evidence. And I'm not saying I've decided that, and I certainly haven't deliberated with my colleagues about it, but that seems like a very odd situation. He's raising a child, but he's unfit, and he's unfit to raise a special needs child, but he's raising one.
Well, the judge was responsible for evaluating the situation for the younger child. The younger child, there's no telling what degree of special needs she would require, but in the judge's consideration, she did not see that the father had ever demonstrated the skills or ability to deal with what he'd be dealing with in a small child with special needs. I see that my time is short.
You can keep going if...
Just to say that that the circumstances for the older boy don't isn't dispositive for some sort of universal ability to parent for the other child.
I agree with that, but again, it's your burden to show by clear and convincing evidence. I certainly wouldn't urge DCF to disrupt the son's placement, but you haven't thought that whatever problems he has are so grievous that you have to remove that child. And doubtless, you don't need a 51A right now. You have all this stuff. My guess is that if you wanted to make the case to the probate court in Worcester that he was unfit, you could do it, right? But you're not. I'm not saying you should. I'm really not saying you should, but it just...
The judge says that he twice stipulated in the trial that he was unfit?
Correct. In 2019 and again in 2021. The trial was held about 11 months after the second stipulation to unfitness. And one of the things that the judge could consider is that in that time, there was no significant efforts or meaningful benefits from the services that he'd done in the past, services that he was involved in. He was still not involved in the DBT therapy, and that the unfitness continued.
Okay, your time has expired. Thank you very much. Very helpful argument. We will hear now from Attorney Papirio.
Good morning, and if it please the court, Mark Papirio representing the child. I wanted to go first to father's fitness as to the other child. And I would say that is a precarious thing. There's testimony in the record that he had that child between 10 and 15 months. It's not entirely clear how long, and of course that there were no 51A reports in that time. But also in that time, he had not yet gotten his son any mental health treatment for his own issues. In fact, he denied his son had any mental health issues and then grudgingly conceded them one at a time as testimony went on and downplayed their significance. He refused to allow the worker into the home and said, you know, if the department wants to come in and see him, they can get a court order. The arguments with the child, the shouting matches, and the mother of that child was actively seeking a return of custody in the probate court when, this matter was going on.
If DCF is involved, if DCF has custody of the child, can you refuse them to come into your house?
You have that right, Your Honor. The department can, if they think that the child's in imminent danger of abuse or neglect, they can come in and they'll get police assistance if they need to, but...
And is that just occurs to me that might be one of the puzzle pieces of exactly how much DCF was involved. If they can't go into the house, maybe they don't have custody. Can I ask you this? Is this termination, though, based mostly on the fact that the child is better off in the current placement, and is that permissible?
That's a huge factor, Your Honor. And that is, back to your question about the RONA standard, what is, I think my brother puts it as, the child's in need of particular skills that the father is unable to provide. That's the quote from the RONA case. And here is what Your Honor was describing. The expert's opinion is putting that child in that home. First, taking her out would create a constellation of special needs for her. She wouldn't know what was going on or understand it, why she's out of the only home she's ever known, and that the second part of 210.3c7, that this father would not be able to handle that. The testimony was you need an extraordinarily skilled parent to deal with the harm that was going to come from pulling her out of that home. But, Your Honor, I wanted to go back to the question about is there clear and convincing evidence in the case. And I think there is for me, even without the expert opinion. We have the father's violence against women, and that is one of the differences in how do they differ. Gender is an important difference because the testimony was as this child approaches adolescence and so forth, the father's not just going to ignore those needs, he's going to, it'll be problematic for the family as a whole. The father's untreated mental health issues, and this is also a failure to comply with or benefit from services. And what I'm talking about is the dialectical behavior therapy. Father's own expert says, this DBT would really help you. 3.5 years had gone by the time that they tried the case, and he still had not started that. He says, well, I have somebody now who knows something about that, but he had not yet begun to engage in it. Furthermore, the failure to benefit, I would say, he took a 40-week batterers course, and at week 37, he gets in another domestic violence incident with the mother. He gets upset that there's going to be an open adoption and confronts her, refuses to let her leave. He's not getting it, at least at that point in time. So I think the refusal to engage as well, not just on the come and get a court order if you want to see my son in my home, but also with this child saying, I don't want you coming around the house. It went back and forth, but generally he was not cooperative with the department until shortly before this trial.
How recently have you seen your client?
Judge, first I'd say I'm always reluctant to venture outside the record, but I saw this young lady last week.
And does she remain in the placement she was in at the time of trial?
She does. I think she was placed at age 3 weeks. She'll be 8 years old at Christmas.
And they are a pre-adoptive resource, I assume?
They are, Your Honor. They're relatives of this child's half-sibling that's also in the home.
Okay. I see no further questions. A very helpful argument as well. Thank you very much. Thank you to all of you. These are, of course, maybe the most difficult category of cases we hear, so we very much appreciate counsel's assistance through argument with them. So thank you. The case is submitted. We will move next. We've already heard case number 3, so we're going to move to what was case number 4. That is Chelsea Sandwich versus Hop Energy, number 23-935.
No West Ham, just Chelsea Sandwich, no West Ham.
Only, yeah, it's only Chelsea Sandwich. West Ham couldn't even. We will hear first from Attorney McLucas.
Good morning, Your Honors. May it please the Court, Jeffrey McLucas for the defendant appellant, Hop Energy LLC. We are here raising on appeal a finding by the Superior Court that Hop Energy breached a provision in a lease for property that it leased from the plaintiff appellee Chelsea Sandwich LLC at the Chelsea Terminal Complex. And the provision in issue relates to an obligation to purchase insurance.
Is there a genuine issue of material fact? Are you saying there ought to have been a trial? Or you're saying no, but that as a matter of law, the judge incorrectly read the contract?
Judge Giles' opinion finding the breach of contract has to be read in conjunction with Judge Green's finding that the plaintiffs essentially vitiated their entitlement to coverage under the policy that was purchased by or on behalf of Hop Energy, not only for itself, but covering the plaintiffs.
But that was, Judge Green's finding was about First Mercury.
That's correct.
And so Judge Giles explained to you, I think at the hearing, you're applying the law of the case doctrine wrong. And she gave you cases, she did the research. I mean, what do you say to that, that the law of the case doctrine doesn't mean that one Superior Court judge can't rule one way as to one defendant and another way as to another defendant, a different judge?
But in looking at the rule of the case, in the sequence in which this occurred, and putting aside the surface of process issue, which remains alive and remains a substantial question, which we have raised repeatedly throughout this matter right from the beginning and is discussed at great length in what we filed with the Superior Court and in our briefs here in the appeals court. In the sequence of what occurred, First Mercury moved for summary judgment. Judge Green made that decision. Judge Green didn't find that the plaintiffs, and most importantly Chelsea Sandwich LLC, had not been insured. What Judge Green found is that the plaintiffs, including Chelsea Sandwich and including Liberty, proceeded forward to reach a settlement, which is the underlying disputed amount of $365,000, without first answering basic questions about the status of these various entities that the global plaintiffs were tendering for coverage prior to the mediation and the settlement.
Wasn't the main reason that Judge Green granted summary judgment for First Mercury is that there wasn't a suit, there was just a claim, there wasn't a suit? And doesn't that support Judge Giles then that the lease provision you're supposed to cover not just suits but claims?
But Judge Green also pointed out that the factual background was that First Mercury made multiple requests prior to the mediation of counsel, not just of what I'll call the global plaintiffs, of counsel for global plaintiffs, that they were making specific reference to a series of entities that were not the landlord as defined by the lease. The lease is very specific. It defines one landlord, not Chelsea Sandwich, its associates and affiliates and related entities. It defines it as Chelsea Sandwich. Having the lease in hand, what First Mercury said...
But that's a fact question, right? It's something we'll never know. If Global had sent them a thing saying, oh, see here, it's a wholly owned subsidiary of ours, and so we're counsel for them too, or whatever, we now do business only under the Global, whatever, some explanation that doubtless would have been accurate. We don't know if, having received that, if First Mercury would just have come back and said, like, well, that's great, then we will send you this letter back saying, yeah, listen, there's no lawsuit, so we're not, right? We don't know that, although I guess there is something in the summary judgment record about it, right? Doesn't, somebody says, maybe First Mercury, I thought there were some deposition testimony or something that they wouldn't have.
There were simply submittals of affidavits in connection with the coverage decision. What Judge Giles notes in the footnote on deciding the cross motions for summary judgment, which is in Appendix 5, it begins on page 141, and on page 148 in footnote 6, Judge Giles specifically notes that it's unknown what First Mercury would have done if it had been provided with the information and an explanation provided. Judge Giles takes the interpretation of that, well, there's no indication that they would have, so it's a breach of the lease provision to provide insurance. But there's no basis for that. All of the correspondence and the communications between counsel for the global plaintiffs and First Mercury were all submitted to the court. There were affidavits that were submitted.
Okay, so if there was evidence, all right, so what is the evidence, right? This is summary judgment motion, so I assume by saying there's no evidence, what she means is there's no genuine issue of material fact because no evidence has been put in that they would have done this. And what's your response to that? What evidence is there?
The evidence is that First Mercury, prior to the settlement being reached in what I believe was on or about November of 2015, never said there's no coverage. What First Mercury said, can you please explain the relationship between these entities?
No, it said both. There is absolutely that sentence, that one sentence, that's the whole case.
But what First Mercury said is, given this, we declined to participate in the mediation.
Because we're not defending you, because
we have asked repeatedly, there were several requests for this that says, we have the lease.
But is it possible First Mercury wants to know who the entities are so that they can do a court record search and find out if there's a pending lawsuit?
Perhaps. There may be any number of reasons, but again, this is being assessed against
this now has nothing to do with Judge Green or law of the case. Is that right? This is simply a question of, I didn't really see you say it this way in your brief, and I'll have to look, of is there a genuine issue of material fact? Is that what you're saying? I don't see it anywhere in your brief, frankly.
I'm saying that Judge Giles' conclusion that Hop Energy breached the lease by not providing the appropriate insurance is based upon what Judge Giles acknowledged was a question of fact. So with respect to the breach, our argument is that there was a question of fact and Judge Giles should not have ruled against Hop Energy at a bare minimum.
And the question is, how would you, Judge, construe this contract, but how did First Mercury construe their own contract? Might they have said, like, yeah, we write suit, but everyone knows comprehensive liability insurance includes this stuff, so it's covered.
And this is why we need to go back to look at Judge Green's opinion. Because
I would think we'd have to go back and have a trial and ask them. I don't understand what Judge Green's opinion has to do with it at all.
What Judge Green noted was that, in essence, there's a cooperation issue. Part of that is you can't move forward, settle a case without our consent, and then require us to pay the amount of that settlement. And so there is a stipulated fact on the record that follows.
That's only, I may be wrong, that's only the insurance company. Under the insurance contract, you can't settle a claim on your own without getting the consent of the insurance company, because that's the pocket that's going to pay.
That's correct.
Well, that claim was settled for $17,500, That has
Your Honor.
nothing to do with, yes.
That settlement of $17,500 was reached with the insurance broker or agent, not First Mercury.
Oh, well, is First Mercury in the case?
Not now. The three defendants of the case to start were First Mercury, Hop Energy, and Hop Energy's insurance broker, PG Gannat. Gannat eventually reached a settlement in the amount of $17,500. First Mercury moved for summary judgment. That was allowed. That has not been appealed by the global plaintiffs. There were then cross motions for summary judgment.
Wait, but the summary judgment, why would they appeal? You would appeal.
I wouldn't appeal.
They said that it wasn't, I thought that was the decision saying, the first decision saying, yeah, you're out because you don't cover this stuff. You cover suits, not claims, so you're out. That's harmful to you, not them, and you didn't appeal it.
That's true, Your Honor. Neither did
Did you ever bring a third-party action against First Mercury?
No, we did
saying,
not.
listen, you actually owe this. What are you doing? They're trying to get $365,000 of ours, but we bought insurance from you. Why aren't you covering this?
Our interpretation of the sequence of events, including Judge Green's order, is that the global plaintiffs essentially failed to cooperate, failed to provide information, and then after being told that First Mercury would not participate...
I still don't understand why you wouldn't have a third-party action against First Mercury.
First Mercury's position was that any problem without any issue on behalf of Hop Energy versus First Mercury was based upon the subsequent finding of Judge Giles that there was a breach of the contract by Hop Energy.
Yeah, but you don't think there was.
No, and neither do the plaintiffs.
But you
who
haven't sued
stipulated
them about it. I found that part of this very odd. Right? You say you went and purchased this really good insurance that totally covered your obligation.
Agreed.
And then First Mercury shows up and says, no, it doesn't. We want summary judgment. Our contract doesn't cover this. And you don't say, slow down, buddy. What do you mean? No, we paid for this insurance.
That's why we go back to Judge Green's opinion. And Judge Green's opinion, in essence, says there were repeated requests for this information, global plaintiffs. You didn't explain it, and you didn't tell them who you were and what the relationship amongst...
So you're
the
not
parties.
asking for a trial on the question of whether they would have gone forward if they'd gotten this. You're saying we should, as a matter of law, based on Judge Green's opinion, hold that the reason was not, it's not a suit, but that the reason was lack of cooperation.
I'm making both of those arguments, Your Honor. We're
In your brief, I'll find that you request a trial.
Yes.
Okay.
Yes, we did. Yes, we did, Your Honor. And that then ties in with some of the other related issues, which essentially is that Judge Giles, despite noting a relevant issue of material fact, which would have dictated denying the cross motions on the breach of contract, Judge Giles, who revisited the same issues at that time as we did in our motion to dismiss at the outset, which was seeking dismissal of the indemnification claim. There's no indemnification clause in the lease. We had raised essentially almost the identical issues on the motion.
That's a legal question, right? You're calling this indemnification, and she concludes it's not indemnification.
At the time of the motion to dismiss, there was a breach of contract claim. There was a contribution claim, despite the underlying person having been identified in the complaint as an employee of Hop Energy at the time of the underlying incident. We moved on all those grounds. So the balance of the counts were dismissed by Judge Giles. And at a bare minimum with respect to the breach of contract action, at an absolute bare minimum, it should have proceeded to trial, based upon Judge Green specifically noting that there was a question of fact as to what First Mercury would have done if the global plaintiffs had sufficiently cooperated. However, at the same time, this is where, and this is what we argued to Judge Giles, we had sought permission immediately following Judge Green's decision. And Judge Green's decision issued before the pretrial conference occurred, and we asked for permission to pursue summary judgment, basing that we did provide the insurance as required by the lease, And as Judge Green indicates in her decision, it was simply that the global plaintiffs jeopardized and nullified that coverage by failing to cooperate and answer the questions, and then proceeding to a mediation, which, by the way, Hop Energy had no notice of, Hop Energy wasn't invited to, Hop Energy didn't agree to in any way, shape, or form. And
Can I also, I just looked at your brief, and the only trial you ask for is about assessment of damages. You say you were deprived of your right to a jury trial with respect to the assessment of damages. You don't say that with respect to the initial claim of whether First Mercury would have covered this or not.
there was a jury claim in our answer, Your Honor.
Yes, I understand that, but in your brief, you say that the right to a jury trial was denied because of this question of reasonableness of the settlement. I'm just looking at your brief.
Well, in part, I mean, we've maintained since the outset that we've been seeking a jury trial on all claims asserted against Hop Energy.
All right, your time has expired, but I've dominated this, so.
Just one question, see if you get the short answer, because I know you devote 40 pages to this in your brief, but why didn't them filing an amended complaint and serving you with the amended complaint cure the difficulties with the first complaint?
Very simply, we go back to when the initial complaint and the action was initiated. So this wasn't this wasn't a separate action that was filed. It was a reformation of the existing complaint to raise issues and identify or to make some modifications based upon what we raised substantively when we served the motion to dismiss the initial complaint. So the operative complaint becomes the amended complaint, but in terms of the obligation at the initiation of the action, it remained the obligation of the plaintiffs to have made that service within 90 days, and they failed to meet the standard for obtaining additional time.
Had you filed your motion to dismiss before the amended complaint?
We served the motion, and we filed with the court a notice of service.
Because of like the 9A rule, or?
Yes.
I see.
That would be the requirement. You file with the...
No, I understand.
Yes.
All right, I see no further questions. Thank you very much.
Thank you, Your Honor. We otherwise rest in our submissions.
And we will hear now from Attorney Murphy.
Good morning. May it please the court, Bob Murphy for the Global Plaintiffs in Liberty. The lease provision in the to procure insurance is valid. Hop Energy claims it's an end run around the workers' comp statute, but in their brief, they dedicate 2 sentences to that issue. They cite absolutely no authority of any kind whatsoever in support of that allegation. We have cited the case, Your Honors, of Norfolk and Dedham Insurance versus Morrison, where the SJC approved.
Okay, an argument, your brother's big argument here seems to be that I don't know if he has asked for a trial on this or if it's just an error of law, that where Judge Giles said there is no evidence that First Mercury would have, if you'd given them information about who CHELSEA Sandwich was, that there is no evidence that they would have covered the claim. But in fact, notwithstanding saying in that letter, there's no suit, they do ask for that. So there's at least some evidence, obviously, I don't know, a reasonable inference is that's not a purposeless request.
They had all the information already that they requested, Your Honor. So before the loss, through the broker, they issued certificates of liability insurance to the global plaintiffs. All of these you'll see in the brief have global in the name. Global Companies LLC, they issued a certificate of insurance for.
What's the record site of the page in your hand?
Excuse me, Your Honor.
What's the record site of that?
The record appendix 3 at 182, and then they go.
Who issues those certificates?
3182?
Excuse me, Your Honor?
Well, actually, can you?
3182, did you say?
Yeah, 3182.
Who issues those certificates?
The broker on behalf of First Mercury.
I mean, I looked at the actual insurance policy.
Yes.
And it says the named insureds are, it doesn't name them. It's bizarre that it's called named insureds. The named insureds are anyone who HOP has a contractual obligation to insure. And so presumably it includes everyone. But you never said that to HOP, and my question is...
Well, we did, Your Honor.
Not in the record, you didn't.
Well, right, there's written correspondence, there's verbal correspondence. What
Okay, but in the
happened with HOP
record, I don't see anything that responds to that letter, whatever it is, the fourth letter,
Excuse me.
right?
The response would have gone against us, Your Honor. They had issued certificate of insurance for everybody associated with Global.
But you didn't write to them and say, we've got a certificate of insurance right here.
We did, Your Honor, but they didn't issue a certificate of insurance for the landlord. So Global is a holding company. All of the other Global plaintiffs are subsidiaries to the holding company. The actual landlord here, which First Mercury knew because they had the lease, which identifies the landlord, is CHELSEA Sandwich LLC.
I agree.
Which they never issued a certificate of insurance for. So the question that they asked me was, you got certificate of insurances and all the names start with Global this and Global that, show us that Global's the landlord. That's the question we never answered to them because we couldn't show that Global was the landlord because Global is not the landlord. CHELSEA Sandwich LLC is the landlord. They never issued a certificate of insurance for Chelsea.
Let me ask you this. It's a little bit different. The judgment doesn't run in this case in favor of CHELSEA Sandwich LLC.
The court issued the judgment on behalf of all of the Global.
I don't care. CHELSEA LLC is the landlord.
That's fine with us, Your Honor.
What's fine with you?
If this honorable court amends the judgment.
Well, we'd have to send it back, but you agree that it ought to have, do you agree that it ought to say CHELSEA LLC, or you think it's a matter of indifference?
I think nobody really focused on it because they were all related in subsidiary companies.
But they're a separate company and an LLC for some reason, right? So.
Yes. So yeah, I do think it should have been the actual landlord.
And the full $365,000 was awarded here.
Yeah.
And interest, even though you already got back $17,500 from whatever that other, the broker.
Okay. At the hearing, Your Honor, I agreed with the court that there should be a set-off for the $17,500.
The judge didn't set it off.
Well, the judge did. It said, for the sake of clarity, the judgment doesn't say it, but the dollar
amount doesn't say it.
Well, I agree with their position, Your Honor. I agreed.
Oh, you agree that this has to go back to be amended down to $17,500?
With regard to the $17,500,
Okay.
but only, Your Honor, because I agreed to it at the hearing
Yeah.
when it was asked. The actual law, they're not joint and several. It's a breach of contract case, so I was actually wrong. But, you know, it sounds like it's a $17,500 mistake that I made.
Well, no, it seems like you already got the other $17,500. It seemed like a mistake.
I think the law was if they were joint and several tortfeasors, they'd be entitled to the set-off, but they're not tortfeasors, it's a breach of contract case. So I was wrong, but...
But your damages have been mitigated then by whatever, I mean...
I'm not dying on that hill,
Yeah.
Your Honor.
So to get back to this question that the whole first half of the argument was about, which is about would First Mercury have, and I do think I can't comprehend HOP not suing them and saying, why am I paying this? I paid for all this insurance.
I think they probably still could if they lose in this court.
I don't know what the statute, I mean, whatever.
Once they pay, they haven't paid anything yet, so once they pay, I think that starts the clock on indemnity, but that's not my issue.
Does what First Mercury would have done or wouldn't have done matter? The question is breach of contract. And I mean, can't you look at what the lease says and what the insurance policy says and decide based on that without deciding?
Absolutely, and they're two separate things. They promised us that they'd get us insurance that responded to claims and demands. This insurance never would respond to claims and demands.
Okay, but this is a weird thing to me. And again, maybe there isn't evidence in this, and maybe it is just a question of reading these two contracts. They were supposed to get comprehensive liability insurance.
Correct.
And you then define it further in the lease to include claims and demands. Now, I have no idea what the practice is in the insurance industry for how they write their policies. My guess is, and I have no idea, that they said to their broker, we need comprehensive liability insurance. Not for your reason, but because they need comprehensive liability insurance. They're doing business. So the broker goes to a bunch of places and gets quotes and says, I think the best one is this. And they get it. And nobody looked at suit versus claim. And someone might have an actual basis for a lawsuit against them saying, you say suit, but this has to mean claim. Because everyone in the industry knows comprehensive liability insurance includes claims and demands. Or the other way, there is no such thing as a claim and demand policy. Every comprehensive liability insurance policy says this.
Those policies are triggered by a claim because the insurance company wants to keep control of the thing.
Sure, of course.
They don't want it to turn into a nightmare and then all of a sudden they're confronted with it. Here, Hop Energy didn't get $1 million. There's a self-insured retention here for $100,000. So the first $100,000 would be.
Yeah, you might call it a deductible, but go ahead.
But it's not a deductible. It is a self-insured retention, which is different than a deductible, mostly based on the timing. The deductible is often collected at the end of the case and is usually $2,500. Here, before First Mercury is going to play, Hop Energy has to spend the first $100. That's the way that policy works. But the way Hop Energy's, so to get back to the original question, all of the information that First Mercury had asked for, they had. The information that they asked for that we didn't provide, we couldn't provide, because there is no way. They wanted one of the people who was issued a certificate insurance to be labeled as the landlord. They're not. There's nothing we can do about that. They're not the landlord. The certificates of insurance were issued to Global Companies LLC. They're not the landlord.
Who asks for the certificates? Or do you just get them because of the contract and Hop goes and gets them? Or you say to Hop, listen, we need our certificates of insurance before you move in or whatever?
I think the policy, the lease demanded it.
Yeah.
You'll get the insurance and you'll give us proof that you got it.
I'm asking Lexus here, but I'm also ask you, is there, in a breach of contract action, is one of the elements causation? There's breach damages. Is there have to be a relationship between the two? Is that where what Liberty would have done, what WWLD, what would Liberty do, comes in?
What would First Mercury do, Your Honor? Liberty's one of the plaintiffs.
Right. Yes, Liberty.
Too many letters now.
Okay.
Yeah.
First Mercury.
I don't think there's an issue at all about what they would have done because they had all the information. What they were saying is if you can prove to us that one of the entities that was issued one of these, like Global Companies.
Isn't that a fact question you're describing?
No, it's it's factual, but it's undisputed. Global Companies LLC.
It's undisputed that if they got some piece of paper from you saying we are the sole owner of Chelsea, or Chelsea's covered under your policy because it says anyone by contract, here's the contract. Your view is they wouldn't have done anything because that sentence about suits trumps it. And what I'm saying is, why isn't there a genuine issue about whether they would have done something or not? Unless they were deposed about it or asked, what if they'd gotten you this? And they said, well, no.
Because they had all the information, Your Honor. The information that we didn't give them, they sent you a letter.
They sent you a letter asking for it. Now, obviously, people do a lot of things in bad faith and blah, blah, blah. But assuming the person writing it wrote it in good faith, like, I still can't figure out who these people are, could you explain again about that? Maybe you have some document that we could see. The response, you have all the information, so I'm not responding, doesn't seem like that's not how people usually do business.
The question they had for us is, can you prove to us that Global Companies, one of the people that was issued the certificate, is the actual landlord?
I don't think it says certificate at all.
The question they asked is, can you prove to us that global companies is the landlord? Global companies is not the landlord. So the answer would have supported the other side.
So they're saying, if the landlord gets in touch with us, and we know from the lease that's Chelsea, they didn't ask about certificates. Now, I know you're saying the only reason they want to know if it was global is that's the one with the certificate.
Yeah.
Are you saying without the certificate, CHELSEA LLC isn't insured at all?
That's First Mercury's position, it's not mine. They should have insured us, and the fact is, they had the lease, so they knew, the question was, who's the landlord? Is Global a landlord? They had 100% information on the exact identity of the landlord.
Okay, so now they're saying the actual landlord, if this is true, the actual landlord has no certificate of insurance. No one asked us for a certificate of insurance for something called Chelsea Sandwich, and so we didn't issue one. And so thanks, Chelsea Sandwich, you're not insured by us. Is that what they're saying?
That's what they're saying, yeah. Otherwise,
that's not the basis of your claim of breach. You're not saying you breached the contract by not getting any insurance for Chelsea Sandwich. That's not. Is that an argument you made ever?
It's in our brief, but it wasn't relied on by the lower court. So I don't think it's.
But you did argue it below? That the failure to produce a certificate of insurance for Chelsea LLC?
No, we argued that the insurance that they produced covered claims, did not cover claims, and it didn't respond to the Trudell case. The only question they asked was, who's the landlord? That's what they're saying we didn't.
I mean, I don't know enough about what a certificate of insurance actually does. The policy says anyone they're under contractual obligation, and they clearly are under contractual obligation to Chelsea Sandwich.
So just to be perfectly clear, the information that they requested was, is Global the landlord? They had already been told who the landlord was. They had the lease. They had lawyers looking at it. They knew Chelsea Sandwich was the listed landlord, and they said to us, show us that somebody with a first name Global is also the landlord, some sort of it doesn't exist. Now, I did have telephone conversations with them afterwards. I had telephone conversations with them right before we served them. So that's what they had asked us. Show me that somebody that has a Global in their name. And the information just didn't exist, so we couldn't. I can see I'm running low on the time.
Your time is actually up. I see no further questions.
Thank you, Ron.
Thank you very much. That's another excellent argument. This is a rather confusing case, so thank you both for your for the edification you've provided. We are going to take our traditional mid-morning break before coming back and hearing the 3 remaining cases. Until then, we stand in recess. Hello again. We continue our argument this morning with another impounded case. This is Doe 527680 versus Sex Offender Registry number 23845. And we will hear first from Attorney Nering.
Members of the panel, may it please the court, my name is Ilse Nering and I represent Doe. Doe was convicted of forcible touching, which is not a sex offense in New York State where the crime was committed. Under this circumstance, as applied to Doe, M.A. Sora infringed on his protected Article 12 due process rights because M.A. Sora did not provide Doe with a means to learn whether his conviction for forcible touching was a like violation that was a like violation before he submitted himself either to the pre-hearing registration process and attended dissemination of his registration data to the police and the FBI, or if he failed to register, be subject to criminal prosecution. M.A. Sora infringed on Doe's due process right to notice because it did not provide to him notice that he would be required to register as a sex offender within 2 days of moving into Massachusetts or be subject to criminal prosecution for failure to register because he had been convicted of forcible touching in New York State.
How would they have effectively given him notice?
I beg your pardon?
How would they have effectively given him notice? That the law in the books here says that if you come into the state within 2 days and you've been convicted of a life offense, you have to register, right? So how would they have given him notice?
On M.A. Sora could be, the like violation could be less ambiguous. It could be unambiguous. It could reference it could reference the foreign laws that are like violations to Massachusetts sex offenses, particularly the foreign laws which are not sex offenses in the jurisdiction where the crime was committed.
Well, but you can imagine, actually in the modern era, I guess you can't imagine, but one might imagine, a state that doesn't have a sex offender registry. It just punishes people for crimes by putting them in jail. And so no offense would be a registration offense in that state. Would your rule apply to all of those cases, or if they were identical, there'd be sufficient notice, you think?
In the United States, every one of the 50 states has a sex
You
offender
can
registry.
imagine a state not having one, though. And there was a time when some states did and some states didn't. I guess, the Supreme Court hadn't said it was constitutional even, in the 70s or 80s. Early 80s. So imagine, or you can imagine a state saying, what is this thing we're doing to people? Let's give them longer prison terms, but no registry or something, right? You can imagine. So now there are no offenses they have to register for. But some of them must be on notice, or not, actually. But my question for you is, would those people, and someone commits it's the same exact elements as one of our offenses, is that adequate?
If, under that hypothetical, there are two ways to solve the problem. Either enumerate the foreign laws that are like violations, or prior to transmission of registration data, prior to the branding of the person a public danger, a sex offender, give that person a hearing with assistance of counsel to determine whether the out-of-state conviction is the out-of-state crime is a like violation to a Massachusetts sex offense, because Article 12 is conferring certain due process rights on people. Does that answer your question?
Well, it does, in a way. You also said that if it were clear or unambiguous that it was a like offense, that there would be adequate notice. So is our job here to see how ambiguous we think it is?
Yes. So I think there are three classes of individuals in that we're looking at. The first class is people who've been convicted of Massachusetts sex offenses. They have notice and clarity. People like Doe 151564 was convicted of a sex offense in Maine, and he had to register in Maine as a sex offender. He came here. He had notice and clarity. My brief is about the third class of people, the people who've been convicted of crimes in other jurisdictions, and those crimes are not sex offenses in those jurisdictions. And then when they cross into Massachusetts, when they cross that border, Article 12 confers on them certain rights. A right to procedural due process prior to being compelled to register as a sex offender, and protected liberty and privacy interest to avoid registration as a sex offender, which covers not being branded a public danger, a sex offender, by transmission of their registration data to the FBI and police prior to a hearing with assistance of counsel to determine whether that crime from another state is indeed a like violation based on the elements, test, and everything else.
But well, no, go ahead.
When you say the New York crime is not a sex offense, New York Penal Law 130-52 says a person is guilty of forcible touching when such person intentionally and for no legitimate purposes forcibly touches the sexual or other intimate parts of another person. How is that not a sexual offense? You're saying just because they don't have to register in New York because the victim is an adult?
Yes, Your Honor. So under the New York Sorrel, if the victim is under 18, then this crime is a sex offense, and the person is required to register as a sex offender in New York State. But when the victim is 18 years and older, it's not a sex offense. So we have crimes that, you know,
it's not a registerable sex offense.
It's not a sex offense that you have. Okay, it's
right.
Yes, Your Honor. It's a crime.
He was accused of rape, right?
It's a crime that has a sexual misconduct element, but it hasn't been designated a sex offense for which registration is required, right, because generally, you know, the federal legislation requires all states to have crimes where there are victims who are vulnerable persons or children. In order to protect the public, these persons who've been convicted of these crimes have to register. But, you know, where the victim is not a vulnerable person or a child, the federal legislation doesn't require the state to make that a sex offense. So New York State deemed that Doe was not a danger to vulnerable persons or children because New York State determined that forcible touching on a person 18 or older did not require registration as a sex offender, because the purpose of the sex offender registry is to protect the public from recidivistic sex offenders who prey on children and vulnerable persons.
Wait, that's the purpose of our sex offender registry or of New York's?
I beg your pardon?
You said the purpose of registration is to protect the public and other vulnerable people.
It's to protect the public from recidivistic sex offenders who prey on vulnerable persons and children. And so that's the bar for the federal legislation. And so as we've learned in the case law in Massachusetts, M.A. SORA has a wider dragnet. It includes crimes which are not sex offenses in other jurisdictions that require registration as a sex offender.
Well, okay, so let me ask you the question a different way. Imagine that New York Penal Law, Section 130.521, had the exact same language as our 13H. So what it criminalized was the person committing an intentional and unjustified touching of the private areas such as breasts, abdomen, buttocks, thighs, and pubic areas, period. Literally the same language. Mm-hmm. Would you still be here? Because it's not a registrable offense in New York? Or is your point it's not a like offense, or there's at least ambiguity about like offense?
The way I would still be here today, because the way M.A. SORA is structured is that the individual does not decide whether it's a sex offense that requires registration. The only way to know whether the crime is a like violation is to first register, and then there's just transmission of the registration data to law enforcement, and then third, the person may request a hearing and then get assistance of counsel, and only at the post-registration administrative hearing or after post-hearing judicial review is it finally determined whether the out-of-state crime a like violation.
Okay, so you would say they shouldn't be forcing you to register and sending information out without determining that it is a like offense in advance.
If we wanted to protect the Article 12 rights of people.
And take my example still. Eventually, of course, in my example, they're going to find it's a like offense because it's literally the same language. Would that be a harmless error in that case then?
I don't think that there's any harmless error where a person's constitutional rights are being infringed upon. A better way to do this would be, obviously the person has to give their information to SORB. Then the person gets a hearing with assistance of counsel to determine whether their out-of-state conviction, their crime is.
So your obligation is to having to register and to having the information sent to other law enforcement agencies, including the FBI.
As we understand from Roe versus Attorney General and the even earlier Doe versus Attorney General's cases, that this is an infringement on liberty interest to transmit, to brand a person a public danger, a sex offender, to the FBI and other law enforcement agencies in absence of procedural due process to determine whether this out-of-state crime is indeed a like violation.
What do you have to say to Mr. Shanai's argument in his brief? He says that if our requirement that Doe register turned on whether or not the New York offense was registrable in New York, then that would lead to situations where another state might have an age of consent of 17 for rape, for example, where ours is 16, and another state might require someone to register for having sex or being rape of a 17-year-old, but here it's not even a crime. So would that be a like offense just because of the fact that they'd have to register?
Well, we don't have that kind of full faith recognition of making people who have to register in out-of-state register here. And again, as the like violation is determined, It's determined by not only the elements being the same or nearly the same, as well as whether the essence of the two crimes. And that can only be done either in a post-registration administrative hearing.
But I guess
or in
then, isn't it a statutory interpretation question as to whether or not like violation in 178C means analysis of the elements of the criminal offense, or whether it also requires consideration of whether the criminal offense is registrable in the other jurisdiction?
To my knowledge, whether or not the person has to register as a sex offender in the other jurisdiction has nothing to do with the like violation analysis. The like violation analysis is, are the elements the same or nearly the same as the Massachusetts offense? And if they are not, then the case law in both jurisdictions is analyzed to determine whether the essence of the two crimes are the same.
Okay, your time has expired. Thank you very much. An excellent argument as always. We will hear now from Mr. Chennai.
If it pleases the court, David Chennai for the board. Really, this comes down to a question about whether or not Massachusetts, through the Sex Offender Registry Board, has the right to protect its citizenry from out-of-state offenders regardless of the laws and regulations of another state. And the board's position is, and the state's position is, that they do have that right to protect the citizens of this state. And one of the things I was thinking about this morning is, if you look at Chapter 140, Section 131C, it specifically says in Massachusetts, you have to be licensed to carry a high-capacity rifle, and if you have that rifle in a motor vehicle, it must be in a trunk, stored, unloaded. Now, another state might have a law that says an individual has the right to have a loaded, high-capacity rifle within the interior of that car. If that individual drives his car into Massachusetts with a loaded, high-capacity rifle, has he broken the law in Massachusetts?
You know the Supreme Judicial Court is hearing that case now.
Yes, that's why I just, that's why I dawned on me this morning. That's when I heard about it.
The difference is that there is a constitutional right with respect to gun ownership. There's no constitutional right to commit sex crimes.
Correct.
Well, let me ask you about the notice piece of this. You agree that it's got nothing to do with the actual facts of the crime that happens to have been committed by the person. It has to do with the elements of the offense.
Correct.
Okay, so in this case, for example, the New York penal law, in some regards, it is narrower in some regards than our 13H. So the purpose has to be degrading or abusing a person or gratifying the actor's sexual desires. And so there are some things in our that might be illegal under our statute that don't have one of those two purposes, and they would still be, you could still be guilty here but not there. But narrower maybe shouldn't have anything to do with it if it's fully covered by ours. But it also says intimate parts of another, and ours says private areas such as breasts, abdomen, buttocks, thighs, and pubic areas.
Correct.
Let's imagine that a New York court has held that the small of the back in New York is an intimate part.
Well, then we'd have an issue here, but I'm not sure that New York has that.
Okay.
The intimate parts is I think you can look at the word intimate parts and assume we're talking about sexual or intimate parts, and I think the sexual would be genitalia, and
well,
the
actually,
intimate
it's
parts
an or, sexual or intimate parts.
Which would be...
It's actually disjunctive.
Well, it's
so
disjunctive.
sexual parts are apparently not intimate parts.
Well, it depends on if is a breast considered a sexual part or an intimate part. That's where I think the line is drawn.
But now I've just, maybe not very well, because I don't know what the case law is, frankly, here about ours or there about theirs. But someone comes into the state and they say, well, I can't quite tell. these are similar, obviously. But I think maybe mine, I think maybe 13052 is broader. And so, and they're not going to look at what I did. So I think it's not a like offense. But when they come into the state, they have to do something, or get arrested, I guess, in order for this issue to come up.
But what happened in this case was the 2017 when he kidnapped the woman and forced her into prostitution, that the board got information that he had this offense in New York State and that he hadn't registered. Now, he wasn't charged in Massachusetts with failure to register as a sex offender, but
that's why he's being, prior to release, I guess, or whatever,
Right.
subjected to this.
so technically he was supposed to register when he came in because he did commit an offense and he was on notice that there was a sexual component to that offense and he could be subject to Massachusetts sex offender registry laws. And we found out when he actually committed another sexual type crime in Massachusetts. And again, that goes to the whole point of the beginning of this, is that we're trying to protect the state from individuals
Sure,
like
but I'm
this.
just asking about procedurally, whether somehow there has to be some kind of proceeding before forcing someone to register, before sending their information elsewhere, where somebody figures out, in the case of at least an ambiguous law, and I'm not saying this is, I'd have to look more closely, but in the case of an ambiguous law, doesn't there need to be more notice?
I think, I think there's two issues in there that you've raised. First of all, given the information, to the law enforcement, I think if you look at the Matthews test that I put out in my brief, I don't think that's onerous enough where there's a real liberty or privacy issue.
You think sending my name to the FBI and saying this is a registrable sex offender, Peter Rubin, here's his address and social security number, whatever you send. You don't think that without any, like if you just did that today, you don't think you'd be infringing my liberty interest?
Well, you got to remember, he's not being made public. It's for...
it's just in case he gets pulled over for speeding and someone runs something on him. Okay.
Right. But since it's not made public, and again, the issue is that by law, once the registration goes into effect, law enforcement has to be noticed, and that's a legislative law. It's not the board's regulations. So,
but the question is the question is whether that can be done without someone sorting out, oh, this really is registrable sex offender.
No, because you then run the risk of a registrable sex offender, and it does take a time to get to the stage where we determine the final, because they have the right to a hearing to determine whether or not it's a like offense as part of the
Yeah, but I'm not talking about the
classification.
statute. I'm talking about whether the or regulations. I'm talking about whether the Constitution requires the hearing to be held, some kind of hearing to be held, before you can do this. I mean, you let someone live here for a day without registering, right? They have to register within 2 days.
Right.
You can imagine some kind of emergency hearing, like in a 209A order or something, where the state has to go in and, get a judge to sign off. Yeah, those are like offenses.
But that would be a judicial issue, not a board issue. The board wouldn't be able to, within 2 days, have a hearing on this. That would had to be taken in front of the judiciary in some way.
Well, why? Your initial determination is done by a hearing officer, isn't it? In real life, in this case, or, when someone says, but it's not a like offense, the first person who hears that is a hearing officer, obviously depending on if they've been arrested.
Right, but that's more administratively done to determine whether or not the individual has the right has to register, and then they send the notice to the individual, not only that they have to register, but what the recommended classification is. Then starts the process for them to request a hearing, and then the production of the evidence and moving towards the classification hearing. So it's the administration of it is takes time. It's not like we have the ability to have an emergency hearing on the matter and bring the individual in for an emergency hearing. We have to compile all the information before we can even make the determination that it's a like offense.
Except he has to register. He has to register first. It takes you a bunch of time to figure it out, but
Right.
he's supposed to know for sure. Or if he has any doubt, he has to do it.
Right, that's the theory based on the statute and the regulation. More of the statute than the regulation. The statute specifically says within 2 days, he has to register, and the information will be provided to law enforcement. Again, that's not a SORB issue, that's a legislative issue. But again, the board's position is that, they discovered that this individual had a LICA violation. I don't think the like violation is being contested here. And because of that, he has to register in Massachusetts, regardless of whether or not the crime he was committed of in New York was registrable in New York, and that Massachusetts has the right to determine its own regulations to protect its citizenry from, in this case, dangerous sex offenders. I think I brought the analysis of the bar, the New Hampshire individual who went to an unaccredited law school and wanted to take the Massachusetts bar. I think it's similar in that sense. The board has the board and the state, I shouldn't say the board, the state has the right to determine what regulations and what laws will be in effect for people who are residing in this state, regardless of what the laws and regulations of any other state are.
But it has to give notice. It may be that as applied in cases where it's ambiguous, it's unconstitutional. I mean, that's Doe's argument, really.
Right, but when we got to the point where the board realized he was here, they gave him notice. They didn't penalize him by bringing a failure to register as a sex offender, but they did bring him notice that they believed that at that time he committed a crime in New York that was a like violation of a crime in Massachusetts. Once he got that notice, he then registered, and then they began the classification process, which includes determining whether or not the board has jurisdiction as a like violation as part of the classification hearing, which the hearing examiner determined it did. And again, that issue is not being litigated here because it's been conceded that it was a like violation. So the issue is whether or not the board had the right to classify him based on the fact that it was non-registrable in New York. And again, the board's position is that Massachusetts has the right with its own regulations and make its own laws to protect the citizens of Massachusetts. And I think I've argued these fairly well in my brief, unless there's specific questions other than what we've discussed. And again, I enjoyed our repartee, but if there's no other questions, I'd be more than happy to rest on my brief.
I see none. Thank you very much.
Thank you.
Very good arguments from both of you, as always, so thank you very much. It's very helpful to us. The next case we will hear is number 22-1241, BUCCI v. Campbell. Now, we have a motion, I gather, from Ms. Campbell seeking to be allowed to argue before us. So our Rule 19 states that a person who doesn't file a brief is not entitled to argue before us. And one of the reasons for that is that if a person files a brief, then the other side has a chance to respond to it rather than hearing an argument for the first time here. So, and I should say, notice was sent. I don't know whether it was to counsel or to you at whatever point, but notice from the court was sent informing you or your counsel that a brief was due and that you should notify the court if you intended not to file a brief. And so far as I can see from the docket, no such notice was returned to the court. So having said that, you will not be permitted to argue, and so that motion is denied. However, we have decided that you may sit at council table, and if we have any questions for you after the completion of appellant's argument, appellant's argument, we'll ask you. And we will hear now from Attorney Pasquarello.
Good afternoon, Your Honors. May it please the Court. My name is Daniel Pasquarello, and I represent plaintiffs and cross-appellants Lawrence and Pamela Bchi. As you note, the defendant's appeal in this case was previously dismissed for failure to prosecute. By way of brief background, this case involves the development of a subdivision in Westford, Mass., and the developer's failure to install a natural gas line for the subdivision. After a jury trial in September of 2022, the jury returned a verdict finding the defendants liable for breach of contract, breach of the implied covenant of good faith and fair dealing, and negligent misrepresentation against Ms. Campbell. We have raised 3 issues on this appeal: that the court's denial of plaintiff's 93A claim was an error, that the evidence at trial demonstrated not only negligent misrepresentation, but intentional misrepresentation, and indeed that there was no rational basis to find otherwise, and that the court's failure to enter directed verdict or JNOV on the breach of contract counterclaim should be reversed. And I would like to take those in reverse order. With respect to the counterclaim for breach of contract, the Campbells asserted 3 counterclaims in the case, which you can find in the record at 103, RA1, 103 to 105. A breach of contract counterclaim that was based on a failure to provide written notice and failure to provide an opportunity to cure, tortious interference with contractual relations, which alleged interference with the escrow disbursement, and trespassed. Now, trespass
wasn't there just a mispleading, though? I mean, there was no third person to interfere with here. Maybe it was that they couldn't pay the vendors because of that was the tortious interference. But by the time it all washed out at trial, their claim with respect to the breach of contract was on the escrow contract, not on the purchase and sale, and that it was the failure to release that last $5,000. That was all their claim, right? And you argued to Judge Liu that, wait a second, that's not what they had in their complaint, and he said, basically, I'm not listening. he said that's between you guys, but if you look at it, under Rule 15 to conform pleadings to the evidence, and then the special verdict question, I mean, wasn't that fairly before the jury?
Well, you are correct that the tortious interference count was directed out by Judge Liu, as was the trespass. So, and defense counsel admitted the only thing left was this interference with disbursement of the escrow. So I gather that was the position that Judge Liu took, but for separate reasons, there still should have been a JNOV on the counterclaim, because the jury returned the verdict that the defendants breached the contract, and the jury instruction was clear and the law is clear.
But weren't we talking about 2 different contracts? The breach of the contract was not providing the propane line. The breach that they were alleging was not allowing the escrow to come to us after we put the blacktop on, or whatever it was.
It's actually the same contract, Your Honor. It's what we called the subdivision contract in the case. I believe it's Exhibit 113. So both provisions are in the same contract. So when the jury determined that there was a material breach by the Campbells for failing to install the gas line, that excused any further performance.
Did you approve the special verdict form?
Did we approve the special verdict form?
You submitted or agree to its use?
Counsel agreed to submit the
Okay, it doesn't say, like one might have thought it would, if you find X, you may skip to question, 9 or whatever, like if you find a breach this way, like don't answer the question about a breach the other way, because there's no more obligation. I understand the jury were instructed on that in one part of the instructions, but the special verdict slip didn't direct them that way at all.
Well, so the court's instruction was clear. The jury instruction was clear that if there is a material breach by one party, it excuses performance by the other party.
I agree, that's in the instructions.
And the law is clear on that as well, and that's in our brief. But in addition to that, there are two things. One, the timing doesn't work out because there's no possible way that the alleged breach by Mr. Bchi could have happened before a breach by the defendants. And we also had repudiation in this case. So the defendants repudiated their obligations under the contract by May 9th to the building inspector, by May 20th to the Bchis themselves, saying, we're not putting in this line, it was never a requirement. So on that basis, you could not then find that there was interference. And I would note on the timing issue, if you look at Exhibit 13, which is the email exchange between counsel, I believe it's June 13th that the defendant's escrow counsel responds.
You're not responding to my question, which is, if the jury doesn't see on the directed verdict sheet that they may only find damages in one direction, only find a breach in one direction, only the first breach matters, how can you complain now that they found both? I mean, if you were presented with that sheet, notwithstanding the instructions, you might think, oh, I guess I'm supposed to answer this and this.
Sure, and that's why we have framed this as this really should have been a JNOV by the judge, because this is a question of law, that it was a violation of his instruction, it's a violation of the law, and in any event, the damages that were awarded here, there's no dispute, the money was paid into escrow, it was sitting in escrow, and it's clear, it's the same $5,357. So if there was going to be a breach here, the proper award would be release of the escrow funds. It's not an award of new damages that the Bchis are supposed to pay. At most, it could be, I suppose, interest on what was sitting in escrow. But if I could move along to the second issue, which is that not only was there negligent misrepresentation here, but there was intentional misrepresentation. And we recognize, Your Honor, the standard, this is a heavy lift. It was a jury verdict that we're talking about, so it needs to be that there's no rational basis in the evidence for this.
What difference does this one make?
The difference...
The judge isn't bound by these findings anyway.
I'm sorry?
In the 93A claim, the judge isn't bound by these findings. So what would you have gotten from intentional that you didn't get from negligent?
Right. I'm sorry, I wasn't at 93A yet.
Well, but I'm trying to figure out why you're fighting about intentional. Would you get something more?
So there is an issue here where this may be relevant to bankruptcy proceedings that are going on that the Campbells have filed. So we think that it is important to get this court's, and in fact, the bankruptcy court allowed us a relief from the automatic stay so we could come back here and flesh out the rest of these issues, including the 93A count, which I will get to momentarily.
So there's got to be no evidence that the jury could have relied on for you to win this one. Ms. Campbell, I read her testimony on her cross, which was actually her direct, and she said repeatedly that there was no conversation about that where she promised that there'd be a gas line, that it never came up, that and that even that when she knew that it was probably not likely, she still was hoping that it could be done. I mean, so couldn't the jury use any of that to find that it was not intentional?
I don't think so, Your Honor, because there was knowledge of falsity before the MLS listing was ever published. And we went through the chronology of this with the communications to National Grid. Ms. Campbell admitted that she made the decision that she couldn't use natural gas and that she was going to have to use propane after her third communication with National Grid following the purchase of the property.
And she also said that she told, in the first meeting, that she actually disclosed that, she said. She testified that she disclosed that. She said it looks like it's not going to happen.
You're referring to the November 5 meeting?
Yeah.
And the only other witness to that meeting, the third party, confirmed Mr. Bchi's account, not Ms. Campbell's.
Okay, but the jury.
The jury can believe her and not the other witness. The jury, right?
So, well, if you... That doesn't solve the problem of the knowledge of falsity here at the time of the listing. So the question on this count is, was there intent for people to rely on the representations? That's the only difference between the negligent misrepresentation count and the intentional here.
And the way it's worded in the special verdict is that to induce you to buy the property, right?
Right, and there's no dispute about that there was inducement, that there was reliance, that there was detriment. And in fact, if you look at the special verdict form here, the only way to make sense of this is that there was some sort of jury confusion on that because it's element 1.
Do we look behind jury verdicts like this?
Well, you look to...
We see inconsistent jury verdicts all day long.
Right, and in this case, you'd have to look to, is there a rational basis for this? So if we're looking at the 2 counts, we have the intent element. That's what we're looking at. And when you look at this verdict form for intentional misrepresentation, they don't go beyond question 1, which is, did she make a false statement? Now, we know that they found that she made a false statement because they found negligent misrepresentation. So there appears to have been some confusion. I'm not sure if it was from the instruction on this. I'm happy to give you the references to the transcript record where this was discussed. The trial court rejected one of the proposed instructions about fragmentary information. They allowed an instruction about future conditions.
Did the Bchi's prove Lindsay Campbell made a false statement of fact to them concerning an important matter with respect to their decision to purchase the property? And she testified, I told them that it was probably not going to happen.
Right, and Your Honor, I don't think that that's a credible read of I understand I'm getting into weight of the evidence here, but if the jury really believed that, they wouldn't have found negligent misrepresentation. And
Well,
again,
actually, we don't know what juries do.
I'm sorry, Your Honor?
We don't know what juries do.
But we do know that they found negligent misrepresentation in this case.
Yes,
So
and you're saying there is no evidence from which one could conclude there was negligent misrepresentation, but not intentional misrepresentation. Why were both questions sent to the jury?
Well, there were 2 separate counts pled, and
okay, but you didn't argue, oh, there's no chance of negligent here. Well, let's take that up. Presumably you wanted negligence there, right?
We did want to include the other count, Your Honor. So what I would say on that is that if that were what they had determined, the checkbox is really there was no intent, not that there was no false statement. So whether this was a splitting the baby or whatever, we've put in our brief pretty detailed the admissions that there was intent to rely, and I think that there's no rational basis to say that there wasn't based on the admissions in the testimony. And if I could move on, unless there's another question on this, if I could move on to the 93A claim.
Yeah, please.
So the trial court applied the inappropriate standard here. I think it was a very brief decision. You've probably seen the language that there was, not the requisite level of rascality, which is a standard that doesn't apply anymore, and if it did, it would only apply to business. The trial court did say that although this conduct was a, quote, a bit sleazy, he didn't think it rose to the level of a 93A violation, and said it was only a breach of contract. Now, what that ignores is the jury found there was negligent misrepresentation at a minimum, and negligent misrepresentation can constitute a 93A violation, and we submit does in this case. There was also, and this wasn't in the brief, but I will note that there's also breach of the implied covenant of good faith and fair dealing, which itself can be an independent basis for a 93A violation. We've provided in our brief the Attorney General's regulation that any person or other legal entity subject to this act who fails to disclose to a buyer or prospective buyer any fact, the disclosure of which may have influenced the buyer or prospective buyer not to enter into the transaction. So that's a violation of a regulation that constitutes a 93A violation. And it's clear that the trial court did not apply the appropriate standard here. So what we would ask on the 93A violation is that you find that there was a 93A violation and remand to the trial court for an appropriate assessment of damages and attorney's fees on that front.
If we were to find that there was a 93A violation remanded to the judge, it'd be, and he found it wasn't willful, and so so that doubling or trebling was not appropriate. Then would your damages still, it would remain the $90,000, and you wouldn't get another $90,000?
Well, in 93A, there would be an attorney's fees award.
The attorney's
so
fees.
we understand that they may not be doubled or trebled, or well, they would not be. They may not be doubled, I will say. So.
And you,
oh, I'm sorry, go ahead.
And so they have bankruptcy protection, but you got a relief from the stay to be able to litigate this?
We did, and the reason this is relevant is because if there is a debt that is touched by fraud, deception, then, and I would say both of these counts play into this, the 93A as well as the intentional misrepresentation, then the debt may not be dischargeable.
Can something be sleazy that's unintentional?
Well, anything is possible. I'm sure it could be, but in this case where we
How
have...
could it be sleazy if it's unintentional?
Well, I'll take your point. I don't think it was unintentional in this case, Your Honor. We've obviously submitted that this conduct was intentional, and that we would ask that the verdict be amended to find that plaintiffs did prove intentional misrepresentation as well as negligent misrepresentation.
Okay, your time has expired, but if there are...
Here's one factual question. When your clients arrived there, was a propane line installed, or was it be a propane tank?
No, there was no propane. In fact, my clients had fitted their house out for a natural gas line.
Okay, your time has expired.
Thank you, Your Honors.
I will check to see. I have no questions from Ms. Campbell.
I have no questions.
Oh, let's give Judge Massing a minute.
No, I don't.
All right, thank you very much. The case is submitted. We are going to reconstitute the panel for the final argument of the day, so we will take literally a 5-minute recess, and the panel will return to hear the final case of the day.